I'm James Fagan. I am a tenant barrister at Chambers. And today I'm going to be speaking to you about one of my favourite cases, which is Hadley and Baxendale. And the reason it's one of my favourites is because it's a case whose principle I'm required to return to on a regular basis when advising clients. Because despite being a case from the 19th century, its well-known, short and succinct statement of principle goes to the heart of contract remedies today, which are fundamental tools for a commercial lawyer. The claimants in the case, Mr. Hadley and another, were millers and mealmen, and they worked together in a partnership as proprietors of the city steam mills in Gloucester. They cleaned grain, ground it into meal, and processed it into flour, sharps, and bran. Unfortunately for them, a crankshaft of a steam engine at their mill broke, and so they had to arrange to have a new one made by a company called EWHC in Greenwich, here in London. Before the new crankshaft could be made, though, the engineers at Joyce & Co. required that the broken crankshaft had to be sent to them so that they could ensure that the new one would fit together properly with the other parts of the steam engine. So, in order to send the crankshaft all the way from Gloucester to Greenwich, they contracted with the defendants, Baxendale and others, who were operating as common carriers under the name Pickford & Co. And what they were simply contracted to do was to pick up the crankshaft for repair and deliver it to the engineers by a certain date at a cost of £2 and 4 shillings. However, Baxendale failed to deliver in time, and this caused Hadley to lose business because without the crankshaft, they couldn't operate the steam mills and they obviously couldn't grind the meal down into the flour and bran. So what they did is they turned around and they sued Baxendale for the lost profits because of the late delivery. And they were successful at first instance. The jury awarded Hadley damages of £25, big sums back in those days. Baxendale appealed, contending that he didn't know that Hadley would suffer any particular damage by reason of the late delivery down to the engineers of the damaged crankshaft. So on appeal, the question became, was Baxendale liable for in a breach of contract case for damages which they say, which the defendant said, they weren't aware of that could have flown from the breach of contract. The Court of Exchequer, led by Baron Alderson, declined to allow Hadley to recover lost profits. They held that Baxendale could only be liable for those losses which were generally foreseeable, or for those losses which would have arisen from what Hadley had mentioned to them as special circumstances in advance of the time of contracting. The mere fact that a party was sending something to be repaired didn't indicate to Baxendale that that Hadley would lose profits if it wasn't delivered on time. So in coming to this conclusion, Baron Alderson stated his now famous principle: where two parties have made a contract which one of them has broken, the damages which the other party ought to receive in respect to such breach of contract should be such as may fairly and reasonably be considered either arising naturally, so to say, according to the usual course of things, from such breach of contract itself, or such as may reasonably be supposed to have been in the contemplation of both parties at the time they made the contract as a probable result of the breach of it. This case has truly been significant in the development of contract law in the common law world. In fact, it was cited in the US Supreme Court back in the 19th century and was incorporated into the US Restatement of Contracts in its second edition. It has seen some refinement over the years as questions have arisen as to what losses are in fact foreseeable and what would require special knowledge in order to be recoverable, the degree of probability that is required by foreseeability in contract law and how that differs from foreseeability in tort law, and this principle's nature as a single principle versus two individual tests. But principle has never been abandoned, and the question today when looking at remoteness and contract damages remains largely the same as it was in the 1800s. Was the loss in the contemplation of the defendant as likely to result from the breach of contract on the basis of the fact that he knew them at the time of the contract, or was the loss something special such that the defendant needed to have told him about it for the defendant to be able to foresee it? It remains an important case because the principle it enunciates is central to the question of contract damages. So much of what lawyers do is not just identifying whether someone has breached their obligations, but in identifying and advising on the remedies available to them. In particular, litigation as a course of business will only make sense if what you stand to gain makes the outlay worth it. And in order to determine that, one needs to have a very good understanding of the principles giving rise to damages and the calculation of them. So again and again, one finds oneself returning to a case about Mills and Gloucester and the statement of Baron Alderson.